Hello, students. So, this is the last module of this session, Foundation of Litigation, Client Handling and Professional Skills. First, client meeting and understanding requirements. See, whenever you meet a client, it is very important that you listens very carefully. What the client wish to communicate, what is his claim, what remedies he is going to sort from the court. These all aspects are very important because this will eventually make your plaint very effective, and this will help your client to win the case. So active listening is very important. Identifying the core issue. Clients often present a mix of emotional grievances and factual events. Your role is to skillfully extract the actionable legal issues and separate them from non-legal frustration. Sometimes client comes because the clients find it out that any petty infringement of their right is actionable. But sometimes it is a matter of fact that how you persuade your client. Sometimes it gets resolved by sending a legal notice only. Sometimes it gets solved by mediating both the parties. There is no need to always approach the court. So it is very important that you identify the core issue. And also, no guarantees. Never guarantee your client or never promise your client a definitive outcome, because litigation is apparently a very lengthy process, right? And the judge have has to abide by the statute, the procedure given under the statutes. So eventually it becomes a very lengthy process, and never guarantee or never promise your clients that this much of time would take to end your case, or this much of time would take to give you a effective remedy. So, fact gathering techniques. Effective fact gathering is the bedrock of any successful litigation strategy. Mastering these techniques ensure you build a robust and evidence-based case. So, open versus closed questions. Start with open-ended questions to elicit the client's full narrative. Transition to targeted, closed-ended questions to pin down specific dates, amounts, and actions, ensuring accuracy and details. It is very important in a good draft that you precisely mention every date, every narrative, every fact that turns out to be your case in a litigation, right? So you have to ask certain questions to your client, like how did you guys met, how things has happened, how things got escalated, how transactions happened, what transactions between you people happen, are they documented, are they only uh, let's suppose if there is a money transaction, so whether it's through online mode or it's a cash, because cash does not give any evidentiary value, it's just a narrative. You can speak up before the court that yes, the cash were given, but there is no documentary evidence with respect to it, right? So you have to question your clients very effectively, very mm, nicely also, that your clients get, I mean, you get the information what you require to build your case, right? Document procurement. Prioritize obtaining original documents immediately. Evidences form the backbone of any legal arguments. Oral accounts alone are insufficient for proving a case in court. As I said, if you'll say that yes, this much of amount has been taken by the opposite party, so that will not suffice your case. It is very inefficient for proving a case in court. So you have to have a very good defense. If you have to have a very good defense, the documents needs to be there to support your claim. The evidences should be there. The back facts rule. Directly inquire about potential counter arguments the opposing party might raise. Identifying weaknesses in your client's case early allows for proactive strategizing and robust defense preparation. Managing client expectations. Client often anticipate quick resolution. See, of course, every client would come and ask you to resolve their queries or resolve their dispute as soon as possible. I also have a lot of clients who says that, sir, please get it done as soon as possible, and I clearly tell them that, see, it is not in my hand. The court has to follow the procedure. Court has to abide by the law books. It cannot go beyond it, right? Only the Supreme Court has power to go beyond the law books, but the subordinate courts does not have it. So it is very important that you speak very clear, tell your clients that this is the timeline which is going to be followed in court. No expectation should be there. It will be a little delayed. There will be a procedural delays. Explain every common administrative and judicial bottlenecks that can extend case timelines beyond initial expectations. Adjournments and hearing. Prepare clients for frequent possibility of case adjournments and the number of hearings required, which are often beyond counsel's control. Sometimes it happens that judge is on the leave, so the adjournment will be given. Sometimes it happens that the opposite counsel is unwell. Sometimes it happens that the opposite party does not came with required documents which are important for the case. So a lot of times adjournments happen in the cases, right? So you have to tell that these are the repercussions. These could be the procedural delays that can happen while fighting the case before the court. Appellate process outline the structured and often lengthy appellate hierarchy, ensuring they understand that initial judgments may not be the final outcome. So you have to also tell your clients that if, of course, first case has to be filed before the subordinate court. So if you lose the case somehow and the judge dictates a verdict against you, so you have appellate authority to go to approach the appellate authority and get it reversed. It's not an issue. You have to tell your client that there is a remedy left. It is not the end result. Confidentiality and trust. The advocate-client relationship is strictly fiduciary, built on absolute trust. Clients must feel secure that any sensitive information shared will remain confidential and protected. Yes, it is also documented in a statute that we should build a client and attorney privilege. So any conversation between the advocate and client cannot be used against the client. This is the privilege that has been given to the client or the advocate, that they cannot use it against each other, right? So strict confidentiality, professional conduct, and fee discussion and engagement. See, it depends advocate to advocate what fees they are quoting, right? So but what I mean, for me, is important that a full transparency should be there. There shall be no hidden charges. Should tell your clients that this much amount is for the drafting. After the drafting, whenever the appearances will be there, I'll charge separate for the appearances. And if there any settlement arises between the parties, this much is the amount, the percent of the amount which you can quote, that this much amount should be given to the advocate. So it is good to clear everything beforehand, because otherwise the client will come and say that, sir, you didn't tell us this could happen and that could happen, right? So it is important to be very transparent about the fee structure, the bills model defined, and out pocket expenses. You should be clear